For our very first workshop, we are trying to just let the activity of moot court be as accessible as possible. So this one is really about introduction to how the courts work, a lot of the jargon that we have in all of our cases that we read, and then also we're getting into a little bit of a brief overview of the cases that are really foundational to the First Amendment, and then what that means for your oral argumentation for any regional competitions that you attend this year. So, without further ado, we're going to get into a brief introduction into constitutional law in general.
Yeah, and we wanted to start with kind of overviews of the court system, the legal system, the process of a case making its way to the Supreme Court, as this year's case is for NAMC. It's totally possible that a lot of you are familiar with this stuff, and that's totally okay. And future workshops will likely be more geared towards experienced competitors. But as Sydney said, this one we kind of just wanted to start from the ground up for anyone who's interested in Moot but hasn't done it before, or people who have done it before, but there's always still things to learn. Um, in terms of the court system and the process of a case making its way up to the Supreme Court, as ours does, cases are generally going to start at what's known as the court of first instance, which is just the trial court. So either a lot of times it's a jury trial or a bench trial where the judge is the one deciding on the case. The jury or the judge will come to some sort of conclusion or write an opinion. And generally, in most instances, those cases are then appealed to some higher state or federal court, where the court will review the appeals and any questions of legal error that might have occurred. So, like in a criminal case where it's a jury trial, usually, and the case gets appealed to the next level, the court is usually not looking at like the facts over again or what's in the record, but rather, were there any legal errors committed at the lower level that need to be reviewed? Um, and a similar concept for our case was the opinion of the lower judge that it contained legal errors or misreadings of precedent or misapplications of precedent that need to be reviewed. Once the appeals happen, you get to a higher level of court. Generally, the second highest level of courts is the U.S. Courts of Appeals, of which there are 13. 12 of these courts of appeals cover like groups of states, and the 13th Federal Court of Appeals covers the federal district system. On appeal from those, the case can then reach the Supreme Court, which only hears a very small number of cases, usually on pretty novel or on controversial issues. In some instances, cases skip the courts of appeals and just go directly from a lower court to the Supreme Court. SCOTUS has a lot of control over which cases they hear, which is why a very large number of cases are appealed to the Supreme Court, and the Supreme Court does not decide to hear the case. It's known as granting certiorari, granting cert. I don't know if I pronounced that correctly. And usually the court will only hear those like most rare cases or controversial cases, either that are hot button issues or like where different lower courts have split in their analysis of cases. In the NAMC case specifically, a lot of the issues that we're dealing with, such as doxing and technology, are pretty novel. There's not a lot of like defined precedent that deals with social media or with releasing people's personal information, because those are all relatively new phenomena. So the Supreme Court might decide to hear that case specifically because they want to set like the first standard or decide what the answer to this question should be, as opposed to cases they've already decided. That process in our case has been, it likely started at trial court, went up to the New Stork Fifth District Court of Appeals, which was then appealed to the New Stork Supreme Court. As we see in our record, the like sample majority opinion and the sample dissent are that New Stork Supreme Court opinion. And then that case was appealed to the Supreme Court. The petitioner is always the one requesting to reverse the lower court's decision. So in our specific case, when Chris Chambers is the petitioner, it's because the lower court ruled against him. He's requesting to the Supreme Court that they should reverse the decision of the lower court. Well, the state of New York is requesting that decision be maintained or upheld. And then in terms of how courts make decisions and what precedent is, the US is in a common law system, as are a lot of former British colonies, which means judges interpret what the law means in cases, decide on like legal tests and so on when they're deciding cases. And this interpretation becomes precedent, or it has precedential value. Precedent is the foundation of all future cases in the US. The court has a strong incentive to maintain precedent, which is the stare decisis principle. If anyone was following the Dobbs case, which presumably a lot of you were, that was one of the rare cases where the Supreme Court decided that previous decisions, Roe and Casey, had been wrongly decided. The Supreme Court wanted to gut all of that precedent, get rid of case law that already existed, and they did that through the stare decisis test, which is some very specific factors that are rarely met that determines when it's okay to overrule past cases. But in the vast majority of circumstances, precedent is binding, the court maintains its precedent, any future cases are built on top of the court's former precedent. Each case has unique circumstances, right? There's always going to be there's a ton of First Amendment cases, all of which say similar things and also maybe slightly different things. And the key question is which precedents, which prior cases or which tests or whatever are the most comparable and applicable to our case. So a lot of times you'll see what looks like on face two cases that might disagree with each other, which we got a lot of last year in our 10th Amendment issue specifically. But it's rare that these cases will be on face totally contradictory. Usually the question is, one of these cases is likely more applicable or more similar to our case, one is different. And it's the advocate's job and the court's job ultimately to decide which precedent matters most for our case. There's two forms of prior cases that can be decided, right? There's binding precedent. Usually when a higher court, so like every decision the Supreme Court makes binds every other court, district courts, appellate courts, and so on, as opposed to cases that are more persuasive authorities. So I'm pretty sure in our case, we have some cases provided to research that are not Supreme Court cases, that might be lower court cases, in which the Supreme Court can look to those, say, okay, the opinion of this judge is interesting, it's persuasive, we think it's probably correct or not correct, but it does not bind the Supreme Court, whereas a past Supreme Court decision does bind the Supreme Court. As I mentioned earlier, precedent can either be favorable or unfavorable. You have to engage with both of them. So I think one pitfall in a lot of oral arguments, both like here and honestly, even as you go higher and higher, including some legal advocates, is just like only focusing on the cases that are favorable to your side or the facts that are favorable to your side, and just trying to forget about the cases or the facts of the precedent that is unfavorable. It's your job as an advocate to engage with both of them. So you're going to get cases in the case packet that are not favorable to your side. Why are those cases less applicable? Why should those cases not be considered as opposed to the cases that are more favorable for your side? Is a lot, I think, of what this activity is and a lot of how judges end up making decisions.
Really quickly before we move on, I just want to connect two terms from these slides. So this idea of binding legal precedent is it's basically in the same vein as talking about, can I go backwards? Yes. Talking about stare decisis, which was somewhere on this slide, but or we'll get to it later, where again, that it's very important that we keep in precedent with what we've decided and what's binding, and then how that informs our future court decisions. Which I think Maria will get to next. So let's move on.
All right, so I'm going to cover a little bit of how legal decisions are written, a little bit of the process, and what types of opinion you can usually see in a Supreme Court decision. So a little bit about the process is after justices hear the oral argument, certain justices are going to write different types of opinions. So certain justices may write majority opinions, dissenting opinions, or concurring opinions. I'm briefly going to go through each of these. The majority opinion is basically the conclusion of the court. It's what literally the majority of justices agree on, and this is the opinion that becomes binding precedent. So connecting to what Sydney said with the notion of stare decisis that I'm going to go into a little bit more later. The binding precedent means that the court must follow the majority opinion of previous cases unless it has a very strong reason to overturn it, but that's quite rare. We also have dissenting opinions, which are just basically judges that disagree with the majority. It can be one justice, it can be multiple justices, there can be multiple dissenting opinions. This is kind of a chance for them to explain their reasoning and explain why they disagree with the majority in the first place. Dissents can be very persuasive, right? Just because they're not binding doesn't mean you have to completely ignore the dissent. It's still really important to give it a read and give it a thorough read to every dissent in every case, because they can be persuasive. It's not like they just don't matter. They're still quite important. They're just not binding. We also have concurrences. Concurrences, either they can add a justice's comment on the majority opinion, or the justice can arrive at the same conclusion that the majority arrived, but they disagree with the reasoning. So they reach the same destination, but they kind of took different paths getting there in the first place. So that's what a concurrence is. And much like a dissent, it's, again, not binding, but it is very, very persuasive. So it's just as important to pay attention to the concurrence and the dissent when reading a case. I cannot say this word, I'm so sorry. I can't say this word, but you can read it on the screen. I've always had a hard time with it. These are rare cases when the majority of the court cannot really agree on a decision. So they're just different scattered opinions. There is a mechanism to decide which opinion is binding, but that's not really important for our purposes. We're not going to get to that today, but just know that this is a type of opinion that you might see when looking at a case. So yeah.
Last year, NFIB versus Sibelius was a plurality opinion. So
yes,
that's one example to keep in mind.
Yes. Okay, so now I'm going to cover some basic legal terminology that is pretty important to know when just dealing with moot court and, considering con law in general. So first, we have a case at bar, which you're usually going to say or hear in oral arguments. It just means you're referring to the current case. So this year, the case at bar is Chambers versus New Stork. Precedent, we keep saying it over and over and over again. It's just previous legal decisions that really do bind the court. And in connection, we have stare decisis. Stare decisis is an extremely important principle. It basically states that the court's decisions must be consistent with precedent, right? So the court can't just write a majority opinion, binding opinion that contradicts precedent directly. However, courts can go against this. Do you have a question? I'm so sorry. Okay, sorry, my bad. I think I just heard someone unmute. I'll move on. Stare decisis, basically, you can only contradict past precedent if you decide to overturn that precedent. And that can usually be done when the court decides that there's something really fundamentally wrong with said precedent. And if the court decides this is when a case can be overturned. So as Vikram noted, Dobbs, for example, overturned 2 cases and went against stare decisis. We have also as applied challenges versus facial challenges to a particular law. So an as applied challenge would be analyzing how the law specifically applies to the petitioner, in this case, Chambers, right? How does the particular law in the case apply to Chambers? And then we have a facial challenge, which means you're just challenging the law more broadly. You're asking whether or not the law is constitutional on its face. That's why it's called a facial challenge. All right. This next term is my least favorite. Just like the previous slide, I also cannot say it. So I'm going to call it writ of cert. And that's completely okay. It's wrong, but it's okay. A writ of cert basically says it's something that the court grants to review the lower court's decision to determine whether it's legally correct. And then we also have another type, which is de novo review. De novo is Latin for from the beginning. Basically just saying it's a standard of review where no deference is given to the lower court's conclusion on matters of law. So the conclusions are not derived from the lower court, for example, whichever court decided the case. It's the Supreme Court making these conclusions. The next two bullet points are very similar. We have reverse versus overrule and overturn. These terms can usually get mixed up in oral argument, which is a very common mistake. And I think it's really important to address them. I've made this mistake myself in many competitions, and it took me a while to learn. Reverse means that you are referencing the lower court's decision. So basically, you're not referring to past Supreme Court precedent, you are referring to the lower court's decision. So petitioner would ask the court to reverse the lower court's decision. And then we have overrule or overturn, which basically is when the Supreme Court is overruling or overturning past precedent, but this is solely exclusive to past precedent. That's why it's different from reverse. And affirm versus uphold has the very same distinction, basically, but on the flip side of the coin, right? Affirm just means that you're also referencing the lower court's ruling. So counsel for respondent would ask the court to affirm the lower court's decision. And to uphold wouldn't just mean that you're referencing past precedent, saying that the Supreme Court is upholding a certain case. I believe that's the terminology.
Yes. For quick reference, if anyone does want to know, I looked it up. It's writ of certiorari. So certiorari, which is the hard part. Yeah, we did this as one of our first practices a while ago. So yeah, that's writ of certiorari. You can also say writ of cert. I'm pretty sure that's equally acceptable in the jargon world. Okay. We've got some questions now. So does anyone have questions on what we've covered so far? Do you want examples of what we mean? We can go over certain slides, certain terminology, whatever you need. So yeah, we'll take a brief second if anyone wants to either unmute or put it in the chat. We'll take a second and wait.
Yeah, we've definitely covered a lot of material. So if anything is confusing as of now, totally okay. We threw a lot at you. So feel free to type or unmute.
We've also got a Kahoot at the end where we can review some of this stuff. So, hopefully if it's not clear now, maybe it'll be clear later. We'll give it another minute and then we'll move on.
Wait, quick question.
Mm-hmm.
So for the applied versus facial challenge, so for applied, would it just go forward to like the specific thing you're arguing? But towards facial, it would just be like, how would you like argue that? Like, how would it be more broad versus like specific?
So Sydney, you can go into it.
Okay. I think sometimes an example helps. So let's say that there's a law that says all dogs must be walked on a leash. Let's say that you have a dog that is, let's say that the dog's name is Spot, and Connor, your dog is like really well trained, and it was a dropout from like a obedience training school and doesn't really need a leash. Not only does he not need a leash, but like the leash makes him anxious or something like that, right? So if I'm arguing this challenge as applied, I'm saying that this law, as applied to Connor's dog Spot, is unconstitutional because of X, Y, and Z. It doesn't actually accomplish the purpose of keeping dogs, I don't know, safe on streets or whatever. However, if I was to argue this on a facial challenge, I would say, no, Your Honor, we should not be looking at just Connor's dog Spot. That is such a specific example. We should be looking generally. Is the law to have dogs on leashes constitutional generally? And yes, we think it does because it applies to the general population where, a lot of dogs need to be on leashes. So does that make sense, that kind of distinction where it's like one is focusing on the petitioner in the case at bar? So for this year's case, that'd be Chris Chambers, while the other one is looking at like the text itself of the law. Does that fall in line with our Constitution's holdings?
Yes, thank you so much.
Yeah, of course. Also, it's so lovely that I get to start learning you guys' names. Any other questions, examples, anything in between? Great. Okay. Again, we will come back to this in our Kahoot. All right. Now we're going to move a little bit into this year's case. A quick note, we will not be answering any questions about the arguments specifically, like how to argue certain things, you can certainly ask if you would like, but I'm just going to tell you right now, we're not going to be able to answer too many things in depth just because we don't want to, give away arguments. Besides, most of the best ones are already in the case itself, so you should be able to find those there. But we're going to go into a brief overview of, I think, mostly the First Amendment, because both issues this year are focused on the First Amendment, and then we'll go into the cases and what that means for your arguments. Maria?
Yes, so this is the First Amendment to the United States Constitution. Basically says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, the right of people to peacefully assemble, and to petition the government for a redress of grievances. So this case in particular concerns the First Amendment. So we're going to focus a little bit more on that and the history of the First Amendment. Awesome. All right. So the history of the First Amendment basically concerns the history of limitations that this court has imposed on the court has imposed on free speech. There are a multitude of cases that are kind of the foundational cases, I would say, for First Amendment jurisprudence. So I'm going to go over those real quick, explain kind of what they mean. Sorry, my Zoom is going a little crazy. Give me just 1 second. My deepest apologies.
Yeah, no problem. Well, you're figuring that out. Oh, yeah, what's up?
Are you still sharing your screen? I, for some reason, can't see the slides anymore.
I am. Is anyone else having an issue seeing the slides screen? I'm gonna take the silence as everything's okay and wonderful.
Jeez.
Let's see. Do you want to try joining on your phone, or you can pull up the slides on like another tab if you want to look through them?
Yes. I can. I think I can just do it without the slides and just go through the cases real quick.
Okay.
Thank you, Coach. Thank you. I think it's my Zoom that's going a little crazy and I can't see the slides for some reason. All right, so I'll go through this without looking at the slides. So if I do anything out of order, please let me know, or if I'm going too fast. All right, so I believe the first case on the slides was Schneck versus United States, and that was decided in 1919. Basically, that case, or that majority opinion of that case, established what we call the clear and present danger test to determine whether or not speech is protected by the First Amendment. The test asks or states that if the speech in question can be reasonably said to create a clear and present danger, such as fire in a crowded theater, it's not protected by the First Amendment. So that's a key limitation that we get from the court on the First Amendment. We have Roth versus United States, decided in 1957, which concerned obscenity. And the court said that content which depicts obscenities or content which is deemed to be obscene is also not protected by the First Amendment. And to sum it up, basically the court said, the First Amendment is not intended to protect every single form of speech. And the reasoning gave credence to the court, saying that that type of speech particularly cannot be said to be constitutionally protected. And then after, we have New York Times versus Sullivan, decided in 1964, which concerned defamation and actual malice. The most important thing to know, I think, about New York Times versus Sullivan is the court established the actual malice standard, basically saying when a statement that is published by the press concerns or is about a public figure, a famous person, it's not enough to show that the statement in question is false for you to sue the press for libel. Instead, the target of the statement, so the public figure in question, needs to show that the statement was made with the knowledge that the statement was false, or with just a disregard for the falsity of the statement. So it's only when the press says, I know the statement is false and I know it's very damaging, but I don't care, then that speech in question is not protected by the First Amendment. But if that's not the case, then the protections apply. After that, we have Brandenburg versus Ohio, decided in 1969. The court in this case basically said that speech can only be prohibited by the states if, first, the goal of the speech is to incite imminent criminal behavior, and two, if the speech in question is likely or even probable to incite or produce such an action. So you need to meet both of those standards in order for a state in question to prohibit speech. And then these last two cases are in our packet. I'm just going to go very briefly through them. We have Hustler Magazine versus Falwell, decided in 1988. Basically, the court held for Hustler right and said the First Amendment protects speech offending public figures, so long as the speech can't be reasonably construed to state actual facts about the subjects, right? So if the speech can't be said to state real facts about the subject, then that speech is protected by the First Amendment, according to Hustler. And then last one, we have Virginia versus Black, decided in 2003 concerning true threats. This case is a little complicated, but the court basically held that states can prohibit speech that constitute true threats. So if the speech in question has an intent to intimidate, then that speech may be prohibited by the states. And the case we have, the NAMC case for the season, asks the question of what do these limitations mean in a world of technology, right? Where online speech is so broad, and how does that interact with doxing? How do all of these limits that we just went through from all of this precedent, particularly the two cases that are in our record, right? Just to clarify, but what does this mean in a world where doxing becomes possible, like publishing private information about the individuals, typically like with malicious intent? So how do the protections apply? When did the limitations not apply, et cetera, et cetera? Those are all very complicated questions that the case for the season is asking. So yeah, I believe that was everything. Sydney, did I miss anything from the slides?
You read it perfectly. Didn't miss a
Awesome.
thing.
Awesome.
One thing to note is that New York Times v. Sullivan is also in our case packet. So we've got 3 on there that are our landmark cases that we just went over today. Very, foundational, but we also want you to analyze some of the other ones we've put there, because you'll need to build arguments for both sides. Also, just to make sure, is everyone familiar with the term doxing and like what exactly that means? I think if you've seen any recent news on the Israeli-Palestine conflict, and especially with student protests, a lot of what's happening now is, especially on college campuses, people who disagree with certain viewpoints are publishing personal information of students, so that this students will sometimes have protesters arrive at their homes. And what does that mean for things like the clear and present danger sort of standard that we set in 1919? So there's all these little things that are coming up with the how technology makes information so accessible, and then asking ourselves, how do we limit that, and do we need to limit that? And with that, let's go into what this means for your arguments. So just to, again, a brief overview, this is a very introductory sort of workshop. We are focusing on simulated Supreme Court law. So the format that we have you doing is akin to, how they actually argue certain cases in the Supreme Court. And you have a petitioner team and a respondent team. Remember, your petitioner team is always arguing that we should reverse the ruling of the lower court. So, and all those circuit courts that we were talking about earlier, they make certain decisions. In our case, it's New Stork, the state of New Stork, has made a certain decision, and the petitioner team, aka Chris Chambers, is asking, can we please reverse the decision because we do not agree with basically how the state has ruled. So your respondent is defending the lower court opinion and saying the lower court's opinion was correct. We need not change anything. So you can think about it like a conversation. You've got petitioner and respondent having an argumentative conversation, if you will. So the way that it goes is petitioner goes first with both issues, respondent goes, and then petitioner has a chance to respond to whatever respondent just said. So that's the basic structure of it. And the way it's broken down from there is that our petitioner team will have both teams will have 2 issues that they're arguing, right? So we've got an issue on parity, that's issue 1, and an issue on doxing, that's issue 2. So with issue 1, you'll be going first, and you'll have 10 minutes on petitioner to give your argument. So I think you can see my cursor, or this first bullet point under this 20-minute argument time. That first 10 minutes will be assigned to students arguing issue 1 for petitioner. Then we go to issue 2 for petitioner. So it's petitioner, but split into 2 sections is what I'm trying to get at. Then we move into respondent, who will have the next 10 minutes to respond to issue 1, and then that following 10 minutes will be for issue 2. And then at the very end, we have rebuttal, which is for the petitioner to then respond very quickly to what respondent just brought up. So I think that the time is a little bit skewed in the slides, and we'll edit this before we send it out again to account for rebuttal. But within that 20 minutes of time the petitioner gets to lay out their arguments, they also have to account for some sort of rebuttal time. So instead of 10 minutes and 10 minutes on petitioner, usually it ends up being 8 minutes for issue 1, 8 minutes for issue 2, and then they have 3 minutes at the end to save for rebuttal. And oh yeah, we've got that lineup right here. So the time splits are a little bit funky for petitioner, but usually the way that it goes is some sort of 8-9 or 9-9 minute split. And then again, to reiterate one more time, you will have to, depending on the issue you're on, you'll either be arguing parody or doxing, and that rebuttal argument will cover both. At each tournament that you attend, you will be arguing different sides in the tournament, so you will be asked to at least do petitioner respondent once, definitely, and then usually there's a coin flip to decide who does petitioner or respondent again. I think that should be all for the basic structure of the case. If you have not had a chance to go through just like the basic case packet that we sent out, it might be a good idea just to do that really quickly probably before January, just so you can get a good sense of where everything is, and then going into the precedent later, so that when competition time rolls around, you'll have your arguments set up for that. So that brings us to another question segment. Does anyone have questions that we just covered? So in the first half, we went over a lot of the basic legal terminology. Now we're diving into the First Amendment. So let's get into some questions. I see Ruth. Yeah, what's up?
Hi, so I was wondering, is there a difference between what anti-doxing laws are, or like, are they put in place against doxing?
That's a great question. And yes, to the second part, they are put in place to limit doxing as much as possible. However, there hasn't been a national or like a court consensus on which laws are actually allowed and which ones aren't, because right now it's being done on a state-by-state basis. And that gets pretty confusing, especially given that technology doesn't really stop state by state. So that's a very good question. And anti-doxing laws are, yes, the same things as doxing laws generally. They're just trying to limit or curtail how that happens.
Thank you.
Mm-hmm. Good question. Anything else? In the meantime, I'll stop sharing. Maria, do you want to pull up the Kahoot?
Absolutely. There's a big prize at the end, which is just bragging rights, to be honest.
Yes. An eternal fame. Let's see.
Let me just make sure everything is.
If you have, let's see, I guess if you're on your phone, you can join on your computer. But either way, if you want, you can join on your phone and just go to like whatever search engine. I think www.kahoot.it. We'll get you in, but we'll get you a code in a second. Any other questions? Okay.
One moment, I'm having some trouble. My computer is not being helpful today. I'm so sorry.
You're good. Okay. I'm going to.
How many U.S. courts of appeals are there? Everyone got it right. Wow. Awesome. Cool. Yeah, 13. All right, so we have Nate first place. What types of opinion can be found in a legal decision? You guys are quick. Incredible.
You should know that earlier, Vikram, Maria, and I went through this, and we were learning things too. So you guys are killing it.
What is precedent? Also, previous legal decisions that do bind the court. Really important. What is stare decisis? Connected to the previous question.
Tricky.
Yeah.
Okay, so yeah, let's go over this one. Stare decisis tries to keep the courts in a consistent line of reasoning with all the previous court decisions it's made before. And it does relate to binding because it means that precedent is binding. I think the confusing thing about this part is that it's not just stating that something is binding, it's that the court must be consistent with everything in the past that has also been binding. That's a little distinction there.
Yeah, this is a tricky question. Does anyone have any questions about stare decisis before we move on? Feel free to unmute or type in the chat. Nope. All right. Next one. Which Supreme Court case established the clear and present danger test? All right, it was Schnecker versus United States. Does anyone remember what New York Times versus Sullivan was? No, that's okay. That was just about publishing information about someone else and when the press is liable to be sued. All right, we have 2 more questions. True or false? A facial challenge concerns the law more broadly. True.
Good job. My spot examples seem to do the trick.
So, okay, last question. False. Does anyone remember the difference? And if not, I can explain, but I just wanted to offer the floor. Okay, no problem. Reverse, you are referring to the lower court's decision. So petitioner is asking the court to reverse the lower court's decision. And when you overrule something, you are referring to Supreme Court precedent. So you are overruling another decision made by the court. That's the difference. So let's see who won.
Yay. Ryan, congratulations, 3rd place. Riley at 2nd. Wonderful. I love these icons.
This is so cute.
I made it so dramatic.
I know.
Yay! It's number 1. Congratulations. And then we've got runners up to Nay and Siona. I don't know if I'm saying your name, but I apologize.
Hey, that was actually cute. Congratulations. Let me stop sharing.
Yes. That pretty much wraps up our very first workshop. Does anybody have any questions? Again, we're trying to make this as non-intimidating as possible, just to make sure that everyone feels comfortable in the moot court space, and especially how, Nancy does it, especially. So any other questions? And then, pretty much you should all be free to go, or you can stay after as well. One thing to note is that for our next workshop, our workshop 2, it will happen in December. We're bringing in someone else to help us run this one. This will be on the strategies and pitfalls in moot court argumentation. So this one focuses much more on strategy and is definitely targeted more at our experienced moot courters or people who are looking to see, down the line what they should be striving to achieve. So if, I guess we'll send out information about that. We'll send out Zoom, everything like that. And then also the slides for today. So if there's no other questions, I hope you all will have a great weekend, and thank you all so much for coming.